Good morning, Your Honors. The matter before the court is the case entitled In Re 181 Parker Hill Road Application, case number 25 AP 060. Appellant Anthony Vetrano is self-represented. Representing the appellee Michael Jasinski is Samuel Angel.
Good morning,
Okay.
Justice.
Yes, thank you very much, and good morning to you. Mr. Vetrano, can you hear me, sir?
Yes, I can, Your Honor.
All right, and we can hear you. You understand you have 5 minutes, and we'll try to give you an alert when you have a short time remaining. So please go ahead.
All right, thank you, Your Honor. Good morning, Your Honors. May it please the court, I am Anthony Vetrano, one of the appellants. This case concerns an application for cannabis cultivation. That application should be denied for 4 reasons, each of which is independent. The first reason is that the application is for operation of a home business. A home business cannot produce odor, but cannabis cultivation produces odor, and this is admitted by the applicant. Therefore, a home business cannot be cannabis cultivation. The second reason is that the applicant wants to cultivate cannabis in his garage. A garage can be an accessory structure for a home business, but an accessory structure for a home business can only be used for vehicle parking, storage, or building access, and therefore an accessory structure for a home business cannot be used for cannabis cultivation. The third reason is that cannabis cultivation requires licensure, both local and state. The applicant has no licensure. The applicant has not even applied for licensure. The entity that has licensure, a limited liability company, is not before the court. The fourth and last reason is, in addition to the lack of licensure, what we have in this case is cannabis cultivation that is a non-conforming use. It is also commercial, and it is also, as I mentioned, odor producing. And all of this is occurring in an area that is residential, that is rural, and it is also a national historic district. And therefore, the cannabis cultivation is having a substantial and material adverse effect on the affected area's character, which under the law is impermissible. Your Honors, I thank you very much for your consideration. And if I may, I'd like to reserve the rest of my time for rebuttal to the extent it's necessary.
Yes, sir. Thank you very much. We'll hear now from counsel for the appellee. Please, for the record, introduce yourself, identify your client, and then proceed.
Thank you, Chief Justice Reiber. It's good to see you, and Justice Maples and Justice Carroll. Congratulations on your imminent retirement. Well deserved. May I sit for this proceeding rather than?
Yes, please. Yes, sir. Please. Yes. Thank you.
Indeed, this matter concerns a cannabis cultivation and growing operation that was a permitted use under the RA5 relevant district, which is a agriculture and low residential district. It was approved by the local municipality, and it was also sustained on environmental appeal. First of all, the operation as a home business cannot produce an odor. There was virtually no testimony at all in the record below that this produces any odors. The appellants themselves, did not hire an expert. The only person that did testify was one of the appellees, and she didn't make any testimony about odors. So that is, I mean, aside from other things, that one issue of odor is not in the record below. There's nothing there. As far as an accessory structure goes, the bylaws are a little bit confusing there, but while it does say that it can only be used for certain uses, it then has examples of uses that are not consistent with the stated only uses. And you really have to look when that kind of situation arises at the bylaws of a whole and the intent of the bylaws as a whole. When doing that, it's very clear that it is a permitted use in agriculture, is a permitted use in this accessory structure. The purpose, in fact, of the RA5 district is to encourage economic activities and agriculture. It is by definition an agricultural district. As far as the cannabis requiring licensure, this is a sole, Parker Hill is a sole member LLC. The operation is going to be carried out by the sole member LLC, and the applicant individually is the landowner. So they have to apply for the municipal permit. They can't. They are the landowner, and it's only a sole member LLC. So that argument is without merit. Regarding cannabis being a non-conforming use, I'm not sure where they're getting that. As far as the historic district goes, there is no special regulation under the municipal scheme for historic preservation. The appellant also makes an argument that agriculture is it does not include cannabis cultivation, citing to state law. However, the statute 7 VSA 869 applies to the required agricultural practices RAP, which this court has recently ruled on in March in a different case, and it applies to other state law, including sales and use tax. For purposes of the municipal permit, the municipal definition can apply and clearly includes cultivation of crops. There is a case cited by the appellant, North Country Sportsman's Club, but it doesn't apply in that case. There was a specific state statute which said that municipalities shall not regulate noise as released from the discharge of firearms at a gun and fish club. And further stated that to the extent that a municipal regulation may conflict with state law, that perhaps the state law would apply in that case. That's not the case here. There is no conflict. The local definition doesn't propel.
You have 1 minute, counsel. You have 1 minute.
Thank you. The local definition does not propel somehow applicants' grow operation of weed into RAP or otherwise offend the state laws. And so it certainly falls under the definition, the municipal definition, which does apply in this case. As a whole, there is a local scheme to produce agricultural products in a low residential density area. That is exactly what my client is trying to do. It is a permitted use with a conditional use permit and site plan approval, both of which he has received. And it follows the statutory scheme. It follows the municipal scheme, and therefore Judge Walsh's determination in the environmental division should be affirmed. Thank you all very much.
Thank you very much. Your time has expired. How much time does the appellant have, please?
Appellant has 2 minutes, 35 seconds remaining.
Mr. Vetrano.
Thank you, Your Honor. With respect to use, the cannabis cultivation is not a permitted use for two reasons. One, it is not permitted in this district, which is limited to low-density housing and agriculture. Cannabis cultivation is not agriculture according to Title VII of the Vermont Statutes Annotated, Section 869A. It cannot be more clear. It is also not a permitted use because a home business is not permitted in this district. And that is why apparently the applicant has applied for a use that is conditional. With respect to odor, the applicant admits in his application that cannabis cultivation produces odor. In terms of examples of uses, the three possible uses, as I mentioned, are parking, storage, and vehicle access. And not all three of those have to be used. One or more can be used, and there is no problem there. In terms of the relationship between the LLC and the member, it is true that the applicant is the sole member of the LLC. But as we know, the LLC and the member are distinct legal entities. They are separate. They are not the same. They are not coextensive. If you have any questions, I'd be happy to respond to them.
All right. Thank you very much. I don't see any hands. Anything else?
Not from appellee's side, your justices.
I'm sorry. I don't think you have that privilege, Mr. Appelli, but Mr. Appellant, you still have time. Is there anything else you'd like to say?
Your Honor, I think, I believe, at least from my standpoint, that this is a clear-cut case for the 4 reasons I specified. In terms of the licensure issue, it appears that the reason the applicant himself did not apply for a license is because he's not eligible to do so. As you know, what he has to obtain first is a local license, and the local license is not available if he has not applied for permits or licensure, which he has not done. And indeed, he cultivated cannabis. He has been cultivating cannabis outdoors without a license, which is, of course, illegal. The second reason he couldn't get a local license is because the cannabis cultivation does not fit with the zoning laws of his district. As I said, that district is limited to low density housing and agriculture.
Okay.
And again,
All right.
thank you.
Thank you. Your time has expired. Please call a conclusion of the hearing.
The next hearing for the court will follow immediately.